Hello, hello. Good evening, everyone. Welcome to Estate Planning and the Black Community. Thank you, everyone, for joining. And as people come into the room, just want to welcome everybody. Hopefully, everybody is having a good evening. All right, as people coming in, welcome. Good evening. Okay. All right. So again, I'd like to welcome everybody to the webinar, Estate Planning in the Black Community. This definitely is a thing that I definitely wanted to make sure that I had this webinar taking place as it was real important to me to address this topic. I know that estate planning is not necessarily a topic that a lot of people find very interesting and probably avoid. But as an estate planning attorney, the more I dig into this, the more I realize and understand just how important it really is that we have this information in our community. So, all right, so without further ado, let's get started. And I will actually hopefully be able to give you guys some information concerning estate planning. All right. So first and foremost, all right, welcome again to the webinar, Estate Planning in the Black Community. My name is Jeffrey Blair. I'm the founder and owner of the law office of Jeffrey Blair, which is an estate planning law firm. Well, there's a verse in the Bible which says, "My people suffer for a lack of knowledge." My people suffer for a lack of knowledge. That's the paraphrase of Hosea 4:6. And pretty much, I start with that because a lot of the issues around estate planning that we see is due to a lot of people just don't understand what it really means, don't really understand how important it is. And when they do get information about estate planning or some of the tools, such as trust, they get misinformation, they get misinformed. And sometimes they try to implement it by themselves and then they really get into trouble. So again, a lot of the problems that we see in this field is because people don't have the knowledge or understanding exactly how these tools are used and just how valuable they are into every household. So let me start off by saying, if you don't remember anything from this presentation, this webinar, is that everyone needs an estate plan. Everyone needs an estate plan. It's not just for the wealthy. It's not just for senior citizens, but if you're an adult, 18 years or older, you need an estate plan. And we're going to go through some of that. So I want to make sure that I say that on the onset. But again, a lot of the time, people don't understand what an estate plan is. Therefore, they sort of maybe shy away from it or just don't even consider it. But it's just really important that everyone needs to have one. All right, so for today's webinar, let's kind of go through an agenda. First of all, just consider this like a personal consultation, as if you're sitting in my office and we're having a discussion, you're asking me questions, and I want to bring you clarity as far as what the law is, and then, sort of give you counsel as far as how maybe you should apply it into your situation. And so in that, I'm going to be talking about the importance of estate planning, in particular in the Black community. We're going to talk about some things historically, as well as what we can do going forward to improve that. And then we're going to do a little deep dive going into wills and trusts, just to understand which type of structure is right for you. And then if you stay to the end, then I definitely have a gift for you. So you want to make sure to stay on for that. All right, with that said, understand that this presentation is for educational purposes. And although I'm an attorney, this is not an attorney-client privilege type of relationship as of yet. You have to have an appointment with me, and then we can sort of talk with each other, understand exactly what your situation is. Then I can be able to counsel you for that. So just understand that. And I have to make sure and say that for the New Jersey Rules of Professional Conduct. So we'll make sure that you're in the right place. So number one, maybe you need an estate plan, but you're not sure where to start. Maybe you're just curious on how long the process will take and what's involved, how much it costs, or any of those things. Maybe you're wondering why you just can't do it yourself. There's a lot of online sources out there now that allow you to get documents here and there. So I want to clarify all those things, and that's why I'm glad that you're here at this webinar, so we can kind of talk about some of these items. So if any of these areas is what you're thinking about, then you're in the right place. And then just to introduce myself again, my name is Jeffrey Blair. I'm the founder of the law office of Jeffrey Blair. We are a family estate planning law firm. That's all we do. We focus on estate planning because it's such an important topic. I'm located in Teaneck, New Jersey, Bergen County. I'm servicing Bergen County, Essex County, and all of New Jersey, really. And here's my contact information. You go to my website. You can find me on Google and all the law reviews as well, and my email and phone number. So you can definitely take a snapshot of that, so you can contact me after this presentation. All right, well, let's start with a few definitions. Number one, what is generational wealth? What is generational wealth? That's a term that we see on the internet quite often, and it's thrown around with a lot of different contexts. But I want to start out with that, and I'll just read a definition that we have here. Generational wealth is the process of accumulating wealth during your lifetime and transferring that wealth to the next generation. And the two words that I have highlighted in that definition is accumulating and transferring. Accumulating and transferring. All right, so accumulating wealth has many different tools or many different activities that contribute to accumulating wealth, gaining more education, getting certifications, getting licenses, focusing on your career and increasing your salary, having investments, purchasing a home, buying real estate, assets, starting a business, just so many different things to accumulate wealth. And I think especially as a Black community, I think that's pretty clear. We're also pretty clear that a lot of times there are obstacles against accumulating wealth over the time here historically in America, whether practices such as redlining, discrimination in employment, whether, education disparities, all these various things definitely are items that may cause us or limit us the ability to accumulate wealth. Yet still, in our resilience, in our strength, in our wisdom, we figured out ways in which to try to work around or fight through that in order to try to accumulate wealth. And so I think some of the latest numbers that I've seen is $1.2 trillion in buying power in the Black community. So definitely there has been a lot of effort in trying to keep us from accumulating wealth, but the Black community has a lot of wealth. We're not where we necessarily should be. We could be a lot further, and there are a lot of efforts that are being made in order to improve that. But it's not nothing. There is something there. And that sort of leads us to the second part of generational wealth, which is transferring that wealth. So once you fight all the issues that you may have in your life in order to accumulate wealth, you make the sacrifices to get your degrees. You make the sacrifices to purchase homes and to do things in order to work around any of those hindrances that are there in order to make sure that you accumulate wealth. The next thing is, how do I transfer that to the next generation? How do I make sure that the efforts that I've placed or I've put in doesn't just become a one generational type of thing, and that the next generation then doesn't benefit from any of that sacrifice at all? So that's why transferring wealth is really where we're talking about when we're talking about estate planning. How do we make sure that any wealth that you have, it could just be a bank account, it could be just $1,000, it could be just one home, it could be millions of dollars, whatever it is, we want to make sure that whatever it is, we do everything that we can legally to make sure it gets passed on to the next generation, and that they can now take whatever accumulated wealth that is and continue to build upon that. That's what estate planning is about. It's the piece of generational wealth of transferring that wealth. So that includes estate plan, which we're talking about today, some of the having a will, having business succession plans, trusts, life insurance, culture and legacy. It's important. This part I have here is because it's not just important to figure out a way to legally be able to pass on the wealth so that it's in a format and a structure that's going to benefit the next generation. But unless they have the right education, unless you pass on the instructions of what to do with this and how to pass it on to their children, your children's children, then they risk making the same mistakes of prior generations of just not structuring it in the right place, in the right way, and then just letting it just benefit one generation and not continue to move forward. So the education and making it a part of the culture and legacy is educating the next generation of not just how to accumulate wealth, but also how to make sure we transfer that wealth in the best way. All right. So I want you guys to think about that. Next time you hear generational wealth, think about it in two ways: accumulating wealth and transferring wealth. And you definitely need to focus a lot on accumulating wealth, but if you don't focus at all on transferring wealth, then it will all be for naught and only last for one generation. We want to make sure that we do something about that. Let me give you some examples. Aretha Franklin, the Queen of Soul, so one of my favorite singers. She definitely had a career that spanned from the 50s and the 60s and the 70s. Like, she's one of those rare artists who was able to just transform, and she was just so talented that no matter what generation she was in, she was just the top. So over her career, she's earned about $80 million. That's how much her estate was worth when she died, $80 million. And definitely worth every penny. She came up through Jim Crow, so she fought for every penny that she has. And you can imagine the struggle that she went through, especially in the music industry at that time, when especially Black artists did not get their fair due. She definitely did what she had to do in order to make sure that she accumulated her wealth. But here's the thing: at her death, there was no estate plan. At her death, there was no will. And then shortly thereafter, there were a lot of handwritten wills that then came to light. Different family members brought them forward, and it started a big, long court dispute between, are any of these wills valid? Which one is the most recent? So basically it was a long court battle, cost lots of money, took a lot of time. So although she accumulated a large number a large sum of wealth over her lifetime, her heirs didn't really get to see that for a long time until they were able to resolve her estate. And number two, it costs a lot of money. So all the expenses that took place, all the different heirs have to get attorneys, all the things that took place over that time, all that money erodes the $80 million. So the money that the heirs actually got was a lot less because it got eroded from all the legal battles. So that's what we want to avoid. Another example. My favorite artist, anyone who's close to me knows that one of my favorite artists is Prince. And when he passed in 2016, it definitely was like a shock. And a second shock was to understand he died and didn't have an estate plan. His estate was valued at over $300 million. He didn't have an estate plan. And now, 8 years later, there's large legal battles going over his estate and his heirs fighting over how it should be divided up. And I know that they've gone through ups and downs where it seemed like they've come to a negotiation, but then someone came back and now they wanted to open it up again. So it can be very messy, very messy. And without having an estate plan, again, you see the estate begin to diminish because you have to spend so much in legal fees to make an understanding. And it is not Prince who's making those determinations. He earned the money, but because he didn't have an estate plan, he's not determining how those funds will be passed on to the next generation. A court's doing that. A judge who's doing that, who really doesn't understand, who probably doesn't understand exactly what his wishes were. So it's another example that I just want to put out there to show if you don't have an estate plan, it could have devastating consequences. Let me give you another example. James Gandolfini, and not African-American, but I just wanted to show him as an example that this is not just a problem for the Black community, although that's what this topic is about. It's a larger society problem. This individual, again, The Sopranos, the series that I loved, was very popular. He made a lot of money. He died in 2013, and he had a will, but he didn't have his estate set up correctly. And because he was a high net worth individual, about 80% of his estate went to taxes. So whatever that number was 10 million, whatever that number was, 80% went to the federal government and state government, and only 20% went to his heirs. Again, it's because not just he didn't have a will, he didn't have a comprehensive estate plan that was going to be able to take care of and make sure that everything is structured in a way so that the heirs, the next generation, gets the maximum amount, and that it doesn't get eaten up with taxes, it doesn't get eaten up with legal fees because of disputes, doesn't get eaten up with creditors. All those things are things that you have to consider when you're passing on your accumulated wealth on to the next generation. That's what a comprehensive estate plan is for. So I don't want you to think that because these three examples are high net worth individuals, that it's only for wealthy people. The logic still still fits. Even if, let's say, whatever his estate was, if it was $10 million, 80% got eaten up. Well, still got $2 million in consideration. That's nothing. That's not nothing. That's something. But it makes even more of an impact for someone who doesn't have that much. If I'm only passing on whatever 100,000, maybe only one home or anything like that, having taxes or legal fees or creditors eat up a large percentage of that, then I'm only handing over a small amount to my next generation. So it's even more impactful to me if I'm not a high net worth individual. So I'm just, bringing these examples of these high net worth people just to show the logic of it. But, hopefully you can kind of get a sense that it definitely is a trap you can fall into if you do not actually go ahead and move forward with a comprehensive estate plan. This may, show that a little bit. So back in 2005 during Katrina, devastated the whole community there. People just totally lost everything. But there was relief that was, earmarked for that community. But you had to show proof that you owned the house when you went back to try to claim it. But guess what? Because it was such an old community where homes got passed down from one generation to the other. Many times they didn't go through any type of estate planning as far as passing on the deed from one generation to the other. So the person alive today didn't have the name in the deed. There was no legal way showing the connection between the person living today and that home, even though everyone in the community know, yeah, that was his great-grandmother's house. It just got passed down from great-grandmother to the grandmother to the mother and now this person. But legally, that person has no claim to that house. Couldn't claim the insurance, couldn't get relief. So lost a lot of property through Katrina because of that. So I'm just trying to show you examples in the Black community in particular, how not having an estate plan has really caused us to lose millions and millions and millions and millions of dollars worth of properties and assets because we didn't have it structured properly. So with that said, it is so important. Why don't more African-American families, African-American people actually start or have an estate plan? Well, surveys have been done, and here's some of the top 10 reasons why a lot of individuals do not think that they need or want to have an estate plan. Number one, I don't have enough assets, so I don't need an estate plan. And I really talked about that a little bit, but estate planning ensures that you have control over your medical and financial decisions, right? So understanding a estate plan is not just about your death. An estate plan also includes what happens to my assets, my finances, what happens to my children if I become incapacitated or disabled, right? That also is included in your estate plan. And so that's why I'm saying it doesn't matter your age, because something can happen to any of us at any age. You need to have an estate plan in place so that your loved ones and that everyone will know this is what I need to have happen in case that happens to me, even before I may pass away. I may become incapacitated, disabled. So it's not just about what happens when you die. It's too expensive. Well, I think as we can see, any of those individuals, whether it was Aretha Franklin, whether it was Prince, whether it was Tony Soprano, whether it was even the individuals that suffered during Katrina, if they had to do it again, they would have spent the money for an estate plan because it would have totally saved them so much in the end, not just them, but also their children and the children's children, if they would have just taken the time and a little bit of money that it took in order to create an estate plan so that there would be no confusion about what happens next. And then they would be able to decide as opposed to having a court decide. That's why it's important that we have an estate plan. Let's start thinking about that. I'll do it later. Yeah, procrastination, that's definitely something that unfortunately, life is unpredictable and we can never, plan for when things may happen. So we have to make sure we have it in place now because we're not sure about what's going to happen tomorrow. But by doing that, we can have peace of mind knowing that if something does happen, that my finances are taken care of, my assets are taken care of, and my loved ones are taken care of. And that truly will give you peace of mind. I don't trust the legal system. Well, if you don't trust the legal system, the best way to fight against that is to make sure you have your affairs legally sound. make sure that you just don't try to do it yourself and go online and try to get some documents and put it together, but you have a trusted professional estate planning attorney, because these are legal documents that can put them in place so that they're ironclad, and to make sure that you then have something to stand on in case there's ever a question about what needs to happen next. You have gone through the right steps in order to make sure that it's sound. Here's one. Talking about death feels uncomfortable or morbid. Absolutely. Yeah, I know it's not always, it's not a fun topic to talk about disability, incapacitation, or death. But, it is a natural course of life, and it's making sure that, again, we take that sacrifice of that conversation, because we and our children and our children's children will benefit from it. So it's worth having that conversation. My family would figure it out. Like, yeah, it's like, they'll take care of it. It's like, oh, what a hardship. Families are already going to be suffering and mourning your loss. So what an extra burden to put on them to say, in addition to that, you got to figure out, what to do with any of the finances or anything like that. I think if we have an opportunity to really at least alleviate that piece of it, then that lets them mourn in peace, because they know everything else has been taken care of. Let's see. It won't matter to me because I'll be gone. No, but it will matter to your legacy. It will matter to the next generation and to your children and to your children's children. So you want to make sure that you address that. It's only for the rich, which we already addressed. It's not only for the rich, because there are a lot of features and tools that are necessary, especially if you're not rich, that you can't afford to make mistakes, because we don't want the next generation to start from zero. Right? We want to be able to, whatever I've accumulated, pass it on to the best of my ability so it doesn't get eroded, and that it can maximize and protect them. And they can benefit that, and they can grow from that as well. I've already had a will. That's enough. We just saw that. It wasn't enough, depending on your circumstance. We have to have a conversation, understand your particulars, so that we can see exactly what it is you would need in order to make sure that you have a robust estate plan that matches what you need. I don't know where to start. It's like, well, being here is a great start. To start giving you at least some outlines, a high level understanding about an estate plan, its importance, and some of the pieces that are a part of it. And then the next step would be to schedule some time with me. We can talk one-on-one, and then be able to go through your specific circumstance. And then I'll be able to show you what tools would work best in order to ensure you have a sound estate plan for you and for your family. So let's see, let's go on to the next slide. So the question is, what is an estate plan? Right? What is an estate plan? So estate planning is the vital, and again, I say vital, I'm very passionate about this because I think it's a missing piece that many of us in our community are not thinking about. So I want to make sure that I spread the education about how important this is. But estate planning is the vital process of legally documenting a strategy to protect your wishes, your assets, and your loved ones during your life and beyond, securing your legacy and ensuring peace of mind for those who matter most. Again, two big words there: legally documenting, so making sure that it's done soundly. Again, an estate plan and documents that make it up all comes from the statutes from in New Jersey, from New Jersey statutes. It legally says this is what we need for a will, this is what we need for a trust, for a power of attorney, all these various documents. So you may write one on your own or go online and get one, but these are state laws. And if it's not specifically aligned with what New Jersey needs or requires, and the laws change all the time, then you may have gone for naught, right? The last thing you want to do is try to do it on your own. And then when your loved ones need it most, find out it's not accepted. You don't want that. So you want to make sure that you utilize an estate planning attorney so that you can make sure that the documents that you need are appropriate for you, and that they are legally sound according to New Jersey statutes. But overall, even beyond the documents, not just about documents, more than that, it's about the strategy to protect your wishes, your assets, and your loved ones. All right. Let's go on to the next one. So that's pretty much what estate planning is. And I want to show you a little bit pieces about the estate plan and why it's important. Number one, it ensures that your wishes are honored. So you accumulate the wealth. So, you have the right to say, how do you want that wealth then distributed to the next generation, or to your heirs, or to your children, or to your children's children? It protects your loved ones and their assets. I'm going to talk about a little bit about how it does that. You could give, if you have any funds or a house or anything like that, you can just pass it on to them. But that has a risk of being eroded if that loved one or that child, has any credit issues, creditors can then just take it. If they have issues with taxes, they can just take it. If they have, there's a lot of different things and risks that can happen with just passing on, whether it's life insurance proceeds, whether it's inheritance, whether it's a home, just outright to the children. There's different ways you can do that to protect it, so that even if that child has some issues, it's protected, right, away from that, and they can make sure that it doesn't get eroded away. Minimize taxes, avoid legal hurdles, right? As you mentioned, there are state taxes that especially if you're a high net worth individual, that you have to deal with if you're going from passing it on from one generation to the other. And I will talk about it in a second. So there are ways we can do an estate plan in order to make sure that we minimize that and make sure that your loved one receives the maximum benefit from your accumulated wealth, and it doesn't go to Uncle Sam. Plan for incapacity and disability. So again, it's not just about when you die, but your estate plan goes into effect even while you're alive. If you are, and again, it doesn't necessarily matter what age. At any age, something can happen to us. But in particular, our aging parents and senior citizens, we're prone to incapacity or disability. Well, what happens to their finances? What happens to the home? What happens to all those things that they've accumulated over their life? Well, an estate plan can work on that too, before death as well as after death. Avoid family disputes. So, a lot of times we speak to clients, that's the number one thing. Like, we can talk about the assets, we can talk about, all these various things, but a lot of times it's dispute, and families end up being the worst thing, right? It causes families to split when we're talking about inheritance and money. So what a great thing it would be is if we got instructions, from one generation to say, this is what I want to have happen, as opposed to guessing what the wishes were. Provide for minor children. And again, another example as to why you need to understand it's not just for someone that's a senior citizen, but also even for any family that has children. If anything happens to you, an estate plan spells out what happens to my minor children. If you have a business, also for business succession planning, what happens if I'm incapacitated or if I pass away to my business? What are the next steps in order so that it can either continue on or maybe even wind down? Either way, the idea is you want to make sure to think through that and then able to put that in a legal document so that it is sound and you can have peace of mind that it will continue along according to your wishes. Maybe there's some charitable causes you want to make sure that you support. Maybe it's your church or anything like that. You can make sure that your estate plan includes that. And also here, just a big thing that a lot of clients also request, maintain privacy. There's a way to do all of this and no one knows what's going on because it's legally sound. It doesn't have to be registered with anybody. It's something that is private for you, especially when you're speaking about a trust, you and your family. And so the details of it and the workings of it is private and not public. And also save time and stress. So I just went through different high notes. There are a lot of different other benefits for estate planning, but just want to hit some of those high notes and hopefully just to let you know just how valuable it is. The bottom line is by doing this, it can give you peace of mind because that no matter what happens, that I've taken care of that my finances and that the next steps going forward, either with my life or even as I pass on, will be taken care of and that it's sound. So let's look a little bit at some of the pieces of an estate plan, right? Some of the key elements of an estate plan in New Jersey in particular. There's a revocable living trust. I'm going to talk in detail about many of these things a little in a second. There's the last will and testament, power of attorney, a very powerful document, healthcare directive, and also Medicaid planning for long-term care, right? For older individuals, make sure that, they'll be able to take advantage of Medicaid, even though if they, own a home. So let me go into these in a little bit more detail, just so you have an understanding about some of these pieces. All right, last will and testament, as far as estate planning, this is probably the one that most people are familiar with. It's, you have a document, you say, on my demise, I bequeath to my son this and to my daughter this, or, I disinherit this person or whatever you want. You go down the list and you name your beneficiaries of any of your assets and then you sort of pass that on. In addition, in a will, you also will have an executor that you would name to say, this is the person that would administer it and be in charge of making sure that my assets get distributed according to my wishes. But the will is also where you would put designation for guardians for my minor children, right? So if that's applicable. So if I pass away, I want so-and-so to be a guardian for my child, that's where you would put that. Also is where you appoint your funeral agents or in your final funeral wishes. You also put that in the will as well. And also any donations, anything like that. So your will is, I think most people get an understanding about what a will is for, maybe some of the things that are in there. But again, it's making sure everything is structured in the right way so that it will be upheld when it goes to probate. So there's some things though, with no will though, if you do not have a will, then it's said the term that's used is intestate. You die intestate, which means you don't have a will. And therefore, the court has to decide what to do. And it has to go by its rules to decide who gets what. So the assets are distributed according to state law. Every state is a little bit different as far as who gets what. If you pass without a will, without you saying who I want. If you have a will, then you can say exactly who you want to have what, but otherwise the state will do that. Kids get inherited at age 18 outright. So if anything that of your assets, your home, anything like that, then they get it outright at 18. And the big question is, 18 years old, can a child really handle a large lump sum? A lot of kids 18 that cannot. So there are better ways to do it than to just give it outright through a will. An example, there's a lot of blended families nowadays. Spouse could remarry after your death. Then that spouse, other spouse, then that new spouse, then is entitled to 50%, half of your house, and they can even win the whole house possibly, or even the assets, and then the children possibly could be disinherited. It can be very messy. Just passing things on outright. So a will is better than nothing, but a will may not be the best thing for your situation. So again, judges have to decide, if you don't have a will, who's going to raise the minor children. A judge would have to decide who controls the children's money. If a child inherits money and they're under 18, well, there has to be a guardianship of who controls the money until they become 18. So, it can be very messy. So wills are a good tool to have as part of estate planning, but there are better tools that can be used as well, depending on the circumstance that you have. So just a thought about minor children again. So if you have minor children again and something was to happen, the question is who will take care of your kids if something happens to you? You can name a legal guardian in your last will and testament, as I mentioned already. And if you pass away without a will, though, a judge will have to decide who gets custody. And it's a long process, an expensive process, where they have to show that we have to actually determine guardianship. And, you really want to avoid that at all costs. You don't want a judge or the courts making a decision about your children. You may pick someone that you may not agree with. So just noting a little bit again, that guardianship proceeding, can be rigorous, can be complex, it can be lengthy, it can be expensive. And that all could be avoided if you just would indicate that in your will. So again, a will is a very powerful tool. All right, next powerful tool, power of attorney, really powerful tool, big part of your estate plan. In this particular case, there are many types of power of attorneys. This one I'm talking about is the durable power of attorney. There's the springing power of attorney, an immediate power of attorney, the general power of attorney. And again, depending on your circumstance, depends on what type of power of attorney you'll need. And so when we sit down and we have our discussion and our peace of mind planning session, you let me know exactly what your needs are. I'll tell you the tools that would be appropriate to apply for that situation. In this case, I'm talking about is a durable power of attorney. And it's a power of attorney where someone can give the power for another person in order to act on their behalf in financial matters. So going into the bank, making deposits, making withdrawals, paying bills, doing investments, doing those various things for you because either you're incapacitated and disabled, can't do it for yourself, or, well, that's really the reason. That's the main reason there. So power of attorney remains to effect until the death. It's just during life. The power of attorney is a powerful tool for managing your affairs, and that's why it's important that we have safeguards in the power of attorney to avoid any type of mishandling. Utilization of power of attorney is the #1 tool that's used in elder abuse cases where a person, a friend, a relative, a caregiver may have gotten power of attorney from an older person, and then they actually utilize that to take funds that they weren't supposed to. So we want to make sure that it's a powerful tool, that we utilize it, but we also place safeguards within it to make sure and to guard against abuse. Also, we want to make sure the power of attorney is executed properly. Again, all these are legal documents. And so the last thing you want to do is try to do this on your own. And then when it's needed, you go to your loved ones, go to the bank and try to utilize it, and the bank rejects it because it doesn't have the proper verbiage, it doesn't have the right execution, or for whatever reason. We want to make sure that it's done properly. That's why it's important to utilize an estate planning attorney for all of these items and not just rely on doing it on your own. But the power of attorney is a very powerful document as a part of an estate plan. And it's also a powerful document when it comes to caring for our aging parents, right? At some point, as our parents get older, they become less able to be able to manage their own affairs. And so it's great that they will have, children, loved ones, relatives that be able to do that, step in for them. And the power of attorney is a great tool in order to be able to utilize that for. If you don't have a power of attorney for an aged parent and they're no longer able to take care of their finances, you can't just step in like that. If you don't have a power of attorney, then you're going to have to go through a guardianship proceeding, very similar to how you would do for a minor child. And that includes the court, that includes cost, that includes time. So it's really good to do this ahead of time before it's needed, and that it's in place so that when it is needed, and that it can be utilized. Power of attorney, very powerful tool. So next thing that we have is the Advanced Healthcare Directive. This is another part. There are two parts to this. There's the living will, where you would indicate, again, this is dealing with not death, but incapacity or disability. If I'm not able to speak for myself, what are some of the end of life or life sustaining measures that I approve or disapprove? Resuscitate or not to resuscitate, take fluids or not take fluids. You'll be able to make those determinations in your living will. In addition, you also can name your agent, right? Who do I want to make those medical decisions for me if I'm not able to speak for myself? And it's good, again, I think vital to have these documents in place before you need them. Because if you need them, then it becomes too late, and then they have to kind of, family members, doctors, whatever, which have to try to decide and figure out what would she want? Would she want this? Would he want that? But by putting it in place now, you can alleviate that. It's already going to be a stressful situation, but by having these documents in place, then you'll be able to make sure that at least they know exactly what I want. In addition, I have someone that I trust that can make these decisions for me. So it's good to have these discussions with your family. So if the time comes, there is no ambiguity and no confusion and no added stress to an already stressful situation. All right. I'm going through these again quickly at high level, and it's so that you just give you a sense that there are a lot of pieces to this, and that we would sit down in our peace of mind planning session. We would go through these. I would listen to you and to the things that you need, things that are important to you, what you're trying to do, and then I would do a deeper dive to let you understand exactly which tools I would consult as to what you would need for that situation and exactly why. So it's okay if it's maybe a little may feel a little overboard of a lot of these items. I just want to give you a sense of some of these items that are necessary for your estate plan. And then we can go into a deeper dive when we have our discussion one-on-one. So one of the big items, one of the most valuable items in your estate plan, if it's right for your situation, is a revocable living trust. And you might have seen this online. You've seen a lot of buzzwords out there, a lot of misinformation when it comes to trust. Trust is a very valuable tool. But some of the things that it claims that it does, it doesn't really do. And some of the things that I don't even talk about, it really does. So it's a really valuable tool. But here's some of the things, right? Avoid probate, unlike a will. So people don't understand. Even if you have a will, it still has to go to probate, right? Even if you have a will, it still has to go to probate. A trust avoids probate altogether. That's where the privacy comes in. Helps you manage assets, not just at death. A will manages your assets at death to say who you would like to pass it on to. A trust manages it now, from the time that you instituted, it manages from that point forward, which includes even during incapacity. It's control over asset distribution. I'm going to talk about it in a second. protects privacy, as I mentioned just now, provides for minor children, protects beneficiaries with special needs, ensures continuity of asset management, minimizes estate taxes. Again, we'll talk about it in a second. Provides for pets if you have pets and wants to make sure that they're provided for. Gifts to charitable donations. Protect assets from creditors, right, for your beneficiaries. Asset distribution to multiple beneficiaries. Planning for business successions. Planning for complex family dynamics. Estate planning for non-citizens. And simplifying multi-state estate planning. So if you have properties in multiple states and you only have a will, you're going to have to go to probate in each state that you have property. If you have it in the trust, then you don't have to. You avoid probate altogether, and things move very smoothly from your generation on to the next without any hiccups. All right, Revocable Living Trust. Those are some of the documents that we have. And go a little bit into this now to kind of see where it fits in and understand. Most of the time, you'll have a package that includes some or all of these documents. Usually, they will circle around either a will-based trust, a will-based estate plan, or a trust-based estate plan, depending on your circumstance. So the question a lot of times is, well, which is best for you? And it depends. It depends on your particular situation, and that's where in our discussion we'll be able to understand what your needs are, but I'll be able to advise as to what structure is best for you. But let me give you some examples, just food for thought. Okay. Will is great, but there are some places where will fails, right? For a will, again, as I mentioned, you still have to go to probate. Some people think you have a will and have to go to probate. You still have to go to probate, which is a public proceeding. A will does not provide for incapacity. It can be problematic across state lines. If children are, at 18, they can get their funds outright. And whatever that amount is, the house, whatever it is, then it's sort of left up to them to manage it properly. In the trust, you can kind of control that a little bit better. Provide direction and protection for a short time at your death, but not during your life. Again, it starts when you die. A trust starts immediately, and not for the lives of your surviving spouse, children, or grandchildren. So at death, this is what happens. Go from here, put it here, and then that's it. In the trust, you have more control. You can control not only how it gets distributed, but also how it gets distributed, even maybe from one generation to the other. So it's a lot more powerful. Wills are great, but it may not be right for your situation. It may be something even better. So the downside of probate, it can be expensive, although I will say in New Jersey, compared to other states, it's not as expensive. Time consuming. All this time while you're going to be going through probate, funds are frozen. They're not going to be passed on to the next generation until everything gets decided and cleared by the court, and it's public. So they have creditors that they monitor probate court to see, hey, this person's in probate and they owe me money. I'm gonna go get what money that's owed to me, different scammers and stuff also monitor probate court because it is a public proceeding. So you want to try to avoid probate if you can. Having a trust allows you to do that. A will does not. All right, so the better option, a revocable living trust. And let me give you an example. So there's Bob. Hi, Bob. So Bob has one asset, $100,000 in a bank account, right? This is just an example. He wants to leave it to his son, Fred, when he dies, but he doesn't want Fred to get the money until he is 25, right? He thinks 18 is just too young. That's the state law. And as an adult, you can receive all the funds from an inheritance. And he also wants him to graduate college first before he gets the funds. Well, guess what? You can put all that in a trust, right? You can't do that in a will. So you would need a trust for that situation. All right, so let me just give you a sense about what a trust is. Let's see. The trust really is a bucket, right? And again, I will talk about this in more detail in our one-on-one so you can understand exactly what it is and if it's appropriate for you. And you as the settler, it was called in New Jersey, you're called a settler, you create the trust, right? We would do that together. And then you also would appoint a trustee who would manage that bucket of trust, right? That bucket which will hold assets. And that bucket, that trust then would be utilized for the benefit of your beneficiaries. All that is pretty much a legal agreement having all these individuals specified who they are. You as a settler, it can be even you as a trustee, and then who the beneficiaries are, right? That would benefit from this trust. And then the second part to that then is once that trust is created is that we would then fund the trust with the various assets, whether it's your homes, whether it's your bank accounts, whether it's your investment accounts. We would take that and we would fund the trust by retitling them in the trust. And then once it's in there, then it becomes a part of that estate. And when it gets passed on to the beneficiaries, it is not a part of their estate, which protects them. It keeps it separate from them as long as it stays in that bucket and in that trust. Hopefully this visualization gives a little sense about it. Again, if it's your first time hearing it, it may be a little bit confusing. But again, in our one-on-one, we can go through it in more detail and hopefully clarify exactly what's going on behind the scenes. But the bottom line is it's an agreement of bringing assets out of your estate, putting it into this bucket so that it can benefit your beneficiaries. As long as in that bucket, there are certain protections that go along with it legally. So why would you need a trust? Why would you need to have that bucket and have it separate away from your children's or the beneficiaries' assets? So one of the things that they poll about parents worry about, after they're gone, that the kids get divorced and the family assets go to strangers. All that accumulated wealth, you pass it on to your child, and for whatever reason, the marriage doesn't work out. Well, then now you just passed on 50% at least of that to someone else, and it no longer continues down in your line. Kids lose their inheritance to creditors and to lawsuits. All that could happen. But if it's, as long as that trust is protected, so the child can still manage it, can get resources from it, but the creditors can't touch it, taxes can't touch it, and divorce can't touch it. That's why a trust can be so powerful in helping continue generational wealth and protect the transfer even when it moves on from one generation to the other. All right. So is each child ready for a huge lump sum distribution of cash? Clients' biggest concern for their wealth after they're gone is that someone will take financial advantage of their children or their grandchildren. Having it in the trust protects against that. So here's another example. Harry and Wendy, right, have two children, Denise and Sam. Now, meet Jason. Jason is Denise's husband. Denise inherits funds, house, assets directly. In case of divorce, Jason gets half. Right. So again, just illustrating what we just mentioned, right? We don't want our children to be divorced, but right now the divorce rate is what? I think more than 50%, more than that. And we'd hate, the last thing we want is that all our hard-earned money would go to someone else and then not benefit our children and our children's children. So having a trust is something where you can protect that. Sam also inherits directly. Sam accidentally left the water running in the bathtub, went out for the night. His downstairs neighbor sued. Sam lost his entire inheritance and settling the claim. Again, because if he gets money outright, it's a part of his estate. If he gets sued, they're going to come after it. If it's in a trust, they can't get to it. That's why a trust is so valuable. Hopefully these examples are good for you. So one of the things and how that's done is what's called a children's trust. And you think of children's trust as sort of like, just think about putting the funds, like say, into that bucket. Let's say that bucket is almost like a tube of toothpaste. So it's in there, but they can squeeze out what they need and the rest stays in there. So in that trust, if they need money to go to school, if they need money to buy a house, they need money for whatever it is that they need, they can pull money out of it, but the rest stays in there and it's untouchable from creditors and from divorce and from taxes or anything like that. So it protects the inheritance while they can still have access to it. That's the power of a trust. In this case, is what's called a children's trust. All right, one more example to show you exactly the power of having trust as well, especially for high net worth individuals. So currently, if you pass on your estate onto the next generation, you're going to possibly incur federal estate taxes. In some states, there are also state estate taxes. In New Jersey, they actually got rid of that a few years ago. But this only is going to really affect someone if they have assets that they're passing on that totaling over $12 million, right? So above that, or $25 million for couples. So again, in our community, it's maybe not a lot, but it's not impossible. And that includes all your assets, all homes, insurance proceeds, assets, stocks, all those things. adding it up. And if it totals over that number, then you have to be concerned about that and make sure you do what you can to structure it in the right way. And there are a lot of different trusts that can be set up in order to make sure that even if you are passing on that large amount of money onto the next generation, there are things you can do. Otherwise, if you just do it outright for any type of protection, then you're talking about maybe almost half that money could be eroded just in taxes alone. There are things we can do to avoid that. In our discussion, when we sit down, we can kind of go over those things, and then we can talk about all the different strategies that we can use to make sure you maximize how much of your assets you're going to be passing on to the next generation, as opposed to having it eaten up with taxes. All right. Gave a lot of information, right? A lot of information. Hope you guys find value in this information that I've given you. We just pretty much have scratched the surface, but I wanted to give you a comprehensive view. When we're talking about estate planning, there's a lot to it. There's a lot of pieces, a lot of moving pieces, and that's why we talk about it's a vital thing that you have an estate plan, but it's also talking about the strategy. How do we structure all these various tools, and there are more, to make sure it addresses your specific need, right? So in these next steps, then we want to make sure that we just don't consume this information, but we also utilize it to make an action plan, right? So right now you're probably thinking, well, what do I need to do? How do we make it happen? When should we get started? What's the investment to get it done right? Those are very good questions to have right now. So let me tell you, we have a process that I have, in my office, and it's pretty much there are 5 pieces to this. First thing, schedule a peace of mind planning session with me. We can kind of get to know one another. I'll get to know your concerns and your situation, and I can suggest certain tools that can be utilized in order to strategize and accomplish your goals. Then, if we decide we're a good fit and that you hire our office, then we come together and we put together a design meeting where we actually design out that plan. And my office will put it all together for you. Then we have a document review session where we kind of go through, based upon what you need. These are the tools that we think we should put together in your package, and we kind of go through it and sort of see exactly and make sure that you're confirmed that it meets your needs. Then we'll have a signing ceremony. That's where we have an official process. We would get together and actually go through and sign all these documents. So an estate planning process, this whole process can take probably about 4 to 6 weeks, depending on how quickly we go back and forth. But in that time, you'll have asked all your questions. I'll be able to give you all the information that you need so you can feel comfortable and actually have peace of mind that you've done everything that you could to not just accumulate your wealth, but also ensure you protected that wealth and transferring it on to the next generation. And of course, that includes, because laws change all the time, and a complimentary annual plan review, and to make sure. And your estate plan should be reviewed at least every 3 years to make sure that it's not outdated. Laws change all the time, and so we want to make sure that we stay in touch so that as things happen or your situation may happen, and maybe you have children, maybe you have divorce, maybe you whatever it may be, that we adjust and update your plan so that it fits your reality. All right, so those are the 5 steps of us making sure that you get peace of mind. So here's the gift. Thanks for sitting through this. Again, I hope that this information wasn't too dense. I hope that it didn't go over your head or anything like that, or that that it was clear that you did find some value in there. So thank you for your patience in sitting through this. So here's the gift. The gift is that if you book a peace of mind session before the end of the month, then you'll receive $250 off your estate plan. Right, $250 off your plan. So that's my gift to you for being here and being a part of this webinar. Thankful for your attendance here, and make sure if you're thinking about doing this, reach out to me. Make sure and schedule some time with me before the end of the month and take advantage of that savings. That's my gift to you. All right, no more excuses. All right, no more excuses. Right. Hopefully, you have the information. You understand why it's so important. You understand that there are a lot of pieces to this, and some of the pieces that you may need, hopefully you got the wheels turning in your situation, whether you are a young family, single mother, whether you are, a senior, whether you're talking about want to look at aging parents, every stage of life, everyone needs an estate plan. And you really shouldn't wait. You should try to do this as soon as possible and make sure that if it's done, that it's done right by professional estate planning attorney. All right, let's see. So with that said, like I said, schedule your peace of mind session, planning session with me. Here's my website, phone number, email. This QR code that you can now zap right now if you want to do that. And you can schedule some time with me. That's the next step. Then we can find about your specific situation, let you know what your options are. All right. Again, well, for taking the time to be with me. Again, hopefully this was valuable. And I ask you that you will please share this information with your friends and family. Let them know how important this is. It's important to me. I'm passionate about this, especially for the Black community, that they have this information. We can avoid so many issues if we knew, and then we do. Thank you again. Enjoy the rest of your evening. Jeffrey Blair, estate planning attorney in New Jersey. Take care.